you to do is to tell me what it is you are wanting to discuss. Go over it all over again
Okay.
because that's how this works.
Okay. Good. Now the thing, okay, I want to discuss because they're trying to the next thing they're going to come with is trying to auction, asking the judge to give them the okay to the auction the house off. Um, that's coming up, and
No, you have to start from the beginning.
oh,
We're
from
not
the
going to talk about the ending. Yes,
okay,
you have to. This is as if we didn't have the first conversation. The first
okay,
conversation was for having given me an idea of being prepared. But however,
okay,
since I talked with you, I've had at least 110 conversations with other people
right.
and 3 consults, and my phone has been ringing off the hook. So compared to including the guy I spoke to this morning, whom he already received an eviction notice because he contacted me after the sale when he
Mhm,
was supposed to contact me before the sale.
mhm.
So let's have your conversation from the beginning.
Okay, and this like been going on for 10 years. Um, the I started off, they with a summary judgment, and which they got that through just fraudulent paperwork. The judge initially told me that they didn't have a legal leg to stand on, um, and then turned around in a summary judgment stating that my lawyer didn't put in for he didn't put himself on record, and she asked him to. He didn't formally put himself on record, although he came in there and although he did motions um, early, but she didn't want to recognize that. And aside from that, so she's saying that was her reason because he wasn't on record formally. Why she denied our she decided for the other side, and on the other hand, she said that I represented myself earlier, so I was familiar with the with the procedures and everything, so I wasn't lacking in knowledge, wasn't incompetent of the stuff that I put in previously before I used this lawyer for the last time to do this to do this summary judgment for me. Anyhow, at one point they submitted a defective assignment. She said it was me that submitted that assignment. It's come to find out it was the other side, and she's and she spoke for the other side. She said that it was a big mistake on their half. They didn't say anything in the court. My lawyers said that no, it wasn't a mistake. They did that deliberately, but she ignored that. She said it was egregious. It was my doing, but after she found out it was the other side, when the other side came back and said yes, it was me, she did nothing. And my lawyer, instead of him putting in a motion to either to get rid of the case or to squash all the information, um, he did nothing. He deliberately argued with it orally instead of putting the paperwork in, stating that they defected the assignment. They submitted a defective assignment, and the reason being because the person that was on the assignment was he was um he was indicted in court. The lawyer, the law firm, Stephen J. Bond. He was the one that was doing a lot of he was a part of the foreclosure mill, and the government came in and only suspended him, and stated that he couldn't not do any more mortgages. That was his penalty, and a $2 million fine. So that was that. Um, so I need to go back and deal with that at some point. The defective documents still in court. Um, and since then, I did 2 bankruptcies. Try to hold off the sale, and to to speed forward. That's pretty much it in a nutshell. Now they're trying to move to to sell a house. Oh yeah, one more thing prior to that, they ex they did not. At one point, they did not. It was in a timely fashion. Even after I did my bankruptcy was over, they didn't move in a timely fashion to submit the papers, and I raised that, and so they did a non-proton, as it was in the beginning, and so the judge said, okay, we can go, although you missed the time to do it, the auction, file for auction date. Although it was late, well, we gonna allow it because all these bankruptcy, this and that he filed, and even after they had long time enough, even after the bankruptcy. But anyhow, they did a non-proton, and the judge allowed it, and aside from that, um, aside from that, the I submitted the not the money order, the the tender. I tendered twice. The first time they defected it, they sent it back. They said it wasn't honored. They defected it and sent it back to me, removing all the language. Um, and the second time, they said they dishonored it again. They didn't send it back. They kept it. So they did. And I did the copy of the first one. I sent them the original. The second one I sent only a copy with a copy written on it. And so they never did give me that back. So they never gave me the first one back, sent the first one back that they defected, but they did send it. They claimed they sent it back when it was defected. They didn't send me the original back. They sent the copy, and they never did send this one back. The second one they never sent back. And they just said they not accepting it. And I asked them more than on one occasion that y'all in dishonor, and I gave more than one. I gave them. I sent them a notice to what's that? A notice to anyway. It's what's the language was? I sent the notice to repair, or they'll find them in default. Three notices I sent them. And they sent me back the same thing that they were not. Even after it expired, I should have went into an arbitration with them because they was way over the time. First, they denied the second one, even after I sent it with the people that, what was that, I sent them through I did it anyway, I did it through not the post. The first one I did through the postal service. The second one I just do through a service. I served them through a service, and in any event, they never sent it back. They never sent the tender back, and they just said they denied it. And I said you have to. UCC said they're supposed to you know either tell me why you're not dishonoring it. I believe it was 3-5 something. Anyway, say if you're in dishonor, if they reject a tender payment, they're supposed to let me know why they're rejecting it. I don't know what offhand what was the UCC, or the debt's supposed to be settled. Anyhow, they haven't sent it back. They just and the last word I got from them is they're just not accepting it, and that's it. And I told them that's not sufficient, and that's not suffice. That should and that as far as I'm considered, it's been settled, and and they also change services from Chase to SPS. All right, so they changed services, and I was going to do something with debt collection on that. I don't know if I still got time to serve SPS. Telling I think it's over 30 days. You can bring a debt collection action on them. Um, but nevertheless, and so that's where we find ourselves. So SPS have it now, and because I wrote the supervisor, the director, and Chase, I kept, you know, just directed my letters to him, my correspondence to him, and I guess they upped it, and now the SPS have it now, and they made a mistake one time when SPS was introducing themselves. They told me that Chase, that is Chase is the owner. No, they told me that Freddie Mac, who is the one that's on my caption. Freddie Mac is on the caption, but you know Freddie Mac will have it. They jumped ship. They jumped ship a long time ago. I guess they got paid. The Remick, Freddie Mac Remick. Because actually it was a Wells Fargo loan. I didn't say that earlier. It was originally a Fred Mac. You know the story with Freddie Mac, not Freddie Mac, Wells Fargo and Chase. That story. Um, anyhow, anyway, Chase had it, and that Chase now sold it to if they sold it at all to them, sold it to SPS. And so now SPS, when they did introduce themselves, they told me that Freddie Mac was the owner, and then they later came back and said no, Chase is the owner. But I have on my caption, it's that's bringing me to court. It's Wells Fargo trustee to Freddie Mac Securities of series of S001-2005. So they're the one that's still on the caption. That's bringing me to court. The Remick. We know that nothing was put in the Remick. I guess that's about that's pretty much it in a nutshell. And now they're moving to try to bring it to auction. The action.
They're not going to be able to bring it to auction. When are they petitioning the court for bringing it?
I have to address the court. It's open. I have to talk to the court. I have to put my papers in opposition to that.
Okay.
By March.
Now, do me a favor. Do me a favor and this is the only way it can work so that we can get through this. When at this point, because you've told me what I needed to know, but at this point, when I ask questions, I'm specifically asking because there's a train of thought. If you give me more than the direct answer, I'm going to lose my train of thought, and that's going to make this really long. So what I'm trying to say is, at this point, I'm asking literally a specific question because there's an angle that I'm going at, and it's something that you're going to need to do. You're going to get an opportunity of having a copy of this video because it will automatically download. When the moment I finish and I hit stop recording, the video will be right there for you to download, so you'll have it to go over in the future. That's the first thing. In the background, what you've been seeing me do is pull up information for you. Okay, this is information that you're going to go to and get this. I'm going to put this link in the chat. So right now, you don't have to actually go here. You can just copy it from the chat and you can go over the information later.
Okay.
Okay. Now, since it's open, the first thing you need to do, you said that the judge already issued a summary judgment because they did an unlawful assignment. Okay, so why haven't you put in for summary judgment a second time?
Right. I didn't do that.
Well, see, my question is, why didn't you? The judge said that she was inclined to do the summary judgment. And here's the next question. Why didn't the attorney, this lets you know I was listening, why didn't the attorney sit up there and do his notice of appearance in the court when he knows that what he's required to do?
Oh, okay. What happened, it was, he did it, but it wasn't in a format they wanted it. Instead of tucked under, it should have been separate from the motions, the other paperwork. It was still there, but it wasn't with the other papers. It was
Oh,
tough.
so she relied on a technicality.
She relied on the technicality.
Oh, no, 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 no. Even if they say that's not, well, why didn't he correct the problem?
He kept telling her it was there. If you see it, it's there. It's there.
And he's absolutely right. But why didn't he stop being stubborn and correct the problem?
that's another issue. And that's why I said he threw me under the
Okay.
bus on one way.
No,
But
he didn't throw you under the bus. What happened is the judge was trying to cause him problems, and he knew
he knew
that if
that.
he kept trying to help you, the judge was going to hem him up because the
That's
judge did not want him helping you. So he didn't throw you under the bus. He did everything right because look at what you were able to accomplish with him there.
right.
The judge was getting ready to throw their junk out. So you still have that as an option. Go back into that court, highlight the fact you're going to do a motion for summary judgment,
Hmm.
the same as he did. But now you're going to add the fact that the court presumed that there was no notice of appearance on file, and there was a notice of appearance. The court is saying that because the notice of appearance was filed, not filed separately, but it was a separate document. Even though it was filed with the other documents, it was its own separate caption, its own separate motion.
Hmm.
So it was separate. The fact that the court uses that, you cannot reward a wrongdoer. And the
Right.
court sat up there and rewarded a wrongdoer. No, you must understand there is a maxim of law. The courts cannot ignore this. They
Hmm.
cannot reward a wrongdoer. And that's exactly what the court did. And that's what you are needing to challenge.
Mm. And besides them defected, they have
Okay.
to do because they defected a document too.
Well, you already have that, but that motion's already written. You're going to take that same motion that's already written and you're going to add to it.
Mm.
And you're going to put that back before the court. You're going to do a motion for summary judgment. You're also going to bring up this other little fact that now I want you to pay attention. The banks took your mortgage and they did a little scheme. And we'll talk about it in a second. But MORTGAGESECURISATION. I'm just going to put for right now mortgage securitization. Yeah, I knew I spelled it wrong, but that's okay. We'll get over it. Okay. The process of mortgage securitization involves combining individual mortgages of similar character into a pool and selling debt securities to draw interest principal payment from the pooled mortgages. That means that this whole group now owns the mortgage. Now, that means that there's what's known as a securitization trustee. You ever heard of one of them things, securitization trustee?
Right. Hmm.
Okay, guess what the securitization trustee is?
A hustler. But go ahead. I don't know. It's right off.
No,
A
no,
per-
no, no. He's not a hustler. He's a trustee.
oh, right. Right. A
The
trustee.
securitization trustee is a trustee, but the securitization trustee operates under this particular form. Let me get rid of this again.
Really. Really. And they really are nobody.
No, they are somebody. Watch this.
Yeah.
Oh, gotta get rid of that.
Is that right? Mm.
SEC. Exact name of the trustee is specified in this charter. Let's click on the SEC.gov because I think they got something to talk about when they talk about securitization trustees.
Hmm.
Oh, look at that. They even have a form for the securitization trustee to fill out. So what you're
Really?
going to bring up is that, and you're going to put together this form. It's called T1. I'll send a link to you. It's called the T1 form. Copy. Just stay with me.
I will.
This T1 form, you're going to put a copy of this form in, and you're going to demand in discovery that they provide a copy of the securitization trustee's T1 form. Okay, now the servicer has nothing to do with this. Let me explain what's going on.
Mhm.
They took your mortgage and they securitized it. They turned it into a security. It's no longer a mortgage. That's why they call it a mortgage-backed security.
That's
It's
correct.
no longer a mortgage. The mortgage has been destroyed. They converted it to a security. People will tell you, um, Well, it doesn't actually mean this. No, it does mean exactly that. It's now a security, and you get them. You do what's known as admissions. Have you ever done admissions before?
No, that's right before. I wonder if I'm still late. Is that late for them? They probably say, "Oh, this has already been decided. I can't."
What do you
That's
mean it's late?
already.
Nothing has been decided. You're doing a motion. You told me that you have opportunity to respond, don't you?
That's correct. That's correct.
Okay, and
It's a
stop doing
counter.
that with me. Stop giving me negatives. I don't care about what you think they're going to say. Have they said it yet?
Right. Nope.
Okay, do you own a casino?
Nope.
Then why are you trying to bet against the house? I don't know why you sit up here trying to predict the future when you don't control the future. We
Right.
don't know what they're going to say. I'm telling you what I'm suggesting you
That's right.
try.
Right. That's right. Oh.
So that when you appeal it, you can now say, I did this, I did that. Let the appeals court tell you did it late. And you say, well, then didn't they do all kind of things late and you didn't penalize them? But when I do something late, you want to penalize me? You want to get on the attorney for filing a document out of order, but then when they file a fraudulent document, you don't want to hold them accountable for it. Are you
Absolutely.
now understanding what we're doing? I'm so glad that you're starting to get it. Okay, let's get back to the securitization trustee and them converting the mortgage into a security. Let's see.
That could be done non-pronto as it was in the beginning.
Really, you're even trying to use legal terminology.
Not that term.
Amazing. Okay, so stop trying to be like them. Okay, stop trying to be like them. Now, I
Hmm.
didn't, I said converting a mortgage into a security. And the first thing they want to do is talking about mortgage backed securities. I didn't
Exactly.
ask about a mortgage backed security. Look, is a mortgage a security? Let's click on that.
Yes, it
Mortgage
is.
backed security. Wait, nobody asked about nobody asked about no mortgage. I said is a mortgage a security? Mortgage backed security. Well, a mortgage backed security is a security, but I'm asking is a mortgage a security? Are called an MBS are bonds secured by home or other real estate loans. Secured by the loan? How can you get a bond that's secured by the loan?
Mm.
Interesting. They are created when a number of these loans, usually with similar characteristics, are pulled together. And since a bank offering home mortgages might round up to $10 million worth of such mortgages. Wait a minute. Are you telling me that the banks securitize mortgages and they pull them together so they can trade them on the market and make money?
Mm.
That's not, no, that can't be what they're saying, is it?
Mm.
Is that what they're saying they do? That they take your mortgage with a bunch of other mortgages, trade them on the market,
That's
and they sell them and they trade them? Wait. Who gave them permission to take your property
absolutely.
and sell it without compensating you?
Absolutely.
Okay, so then you need to be contacting the SEC and saying, wait a minute, my mortgage for my home, my loan, somebody's making a profit off of it by trading it on the market, and I'm not receiving any compensation. I need to file a complaint. File your complaint. Put that into the record.
Mhm.
Look, you're a record company, and you have this artist that you just put out, and this artist is selling. He's the number one seller in the world. And then you find out your rival is selling the same material that you're producing. He's
Mm.
selling it, and he's making a bigger profit than you are making.
That's the
Do you just keep letting him make a profit off of your
right intellectual
property?
property.
What do you do? So
So
why are you letting them trade your property on the market, making a profit off of it, and then charging you to let them sell your property on the market? Do
mm.
you understand that they don't have the right to sell your property on the market, but you gave them permission by the papers you signed? But the papers you signed says that you were supposed to receive dividends, that you were supposed to receive the benefits of that as well. You are an investor, and you don't realize that. So when you contact the SEC, say, I'm an investor and I'm being defrauded because I am not receiving my dividends. There's a form for that. Fill out that form. Then you document that that securitization trustee has that T1 form. Hey, the securitization trustee, you know what he can't do? He can't be involved in foreclosures. He's only supposed to be involved in securities. This is what this is all about. He is not. That's why you're introducing this. He is not supposed to be involved in anything but securities. The Security Exchange Act and the Security Exchange regulations prohibit him. Okay? Prohibits him from engaging in such activities.
And they're using the law firm as a debt collector.
Well, doesn't matter. They can use the law firm as a debt collector because it has nothing to do with this conversation. Do you see what I'm saying? Train of thought. So I have to stay on my train of thought, not yours, because I'm giving you what they like to refer to as arguments to bring up in court. Okay, these are the arguments that will solidify your position. That's what I'm doing.
I got you.
I am trying to make sure that all the junk that they're doing, that you put stuff on the record that they cannot get around.
Right. And it is under UCC, and it is under UCC 8, 3 and 4.
I could care less.
Right.
No, it's actually, you're going to actually find most of it under UCC 9.
But
9 is what deals with securitization of mortgages. They created that specifically so that they could securitize mortgages and foreclose on people's homes. Go back and look at the reason why they did UCC 9. That's why you have the UCC forms. They're all under UCC 9.
I thought it was under UCC, all securities.
Nope. Number 9 was created especially for mortgages.
Oh, really?
Remember, they weren't always doing mortgage-backed securities. All this terminology they created through the Uniform Commercial Code. The Uniform Commercial Code is not even a law. Congress did not enact that. It was a bunch of lawyers that came together and put that junk together. Go ahead, do your research and see the Uniform Commercial Code is only accepted by the courts and everything is this, that, and the other, but it is not law. Now, every state has a Uniform Commercial Code. Congress enacted that in every state, but the one that's done by the United States, please. Ooh, doggy. All right, let's get back to this so that we can stay on track.
Yeah, I see.
What the securitization trustee did was he represents all of those different owners. They pooled all their mortgages together, and the agreement allows the trustee to act in the best benefit of the so-called owners. However, the trustee may have the power of sale in that agreement, but he does not have the power of sale in your deed of trust. Not the same trustee. He does not have the authority under the deed of trust. But hold on, there's an argument that the courts have been saying you cannot bring. You know, they cannot separate the note from the mortgage. The note from the deed of trust. They cannot be separated.
Okay.
Well, no, because the court said that they can.
Right. And they're trying to say that you're not a party of it. Or what goes on.
Well, you are a party to the deed of trust. Of course you are, because you're the one who signed the agreement. Of course you're a party. You're not even a third party, especially the securitization, because you're the one who permits it. It's your property that's being sold. You are a party to the agreement. Of course you're a party to it. They say that because people don't know how to come back with it. So you simply say, wait a minute, I'm not a party to it. So you're saying that I didn't sign the note? Are you saying I'm not a party to the deed of trust? You're saying I'm not the borrower, so I'm not responsible for payments? Thank you. Oh, man. Hey, she just said I ain't got to pay no more money to these mother. What? You just said I'm not a party. According to the deed of trust, it says that I agreed to pay these mothers, and you're saying I'm not a party to it. Thank you. Thank you. Thank you for being, that's exactly what I wanted to hear today. Hey, all right, thank you. Hey, she just said case over. Okay, you think I'm lying. You think I'm lying. I won't do something like that to these ignorant mothers, because that's exactly what they're saying. Of course you're a party. Of course you're a party to the securitization of your loan, because without your permission, they are not allowed to trade your property. Listen, ask me if, go ahead.
And that's another thing about us giving them our signature is being giving them the okay as a credit. Credit during the mortgage.
Stop that. Stop
Okay.
that. Stop that. What you doing? Our signature. Where'd you get that junk from?
Not so much the signature, but then we giving them
Where,
we
no,
are
where'd
the
you no
credit.
no where'd you get that's my question is where'd you get that junk from? I don't see no law that says that. Where'd you get that from? Let me go there right now.
Okay,
Which code is that?
okay, I got
Which constitutional amendment was that?
you.
What senator said that? What's one of the
One
founding
person that said
so-called
that.
wannabe
Right.
lynching
We are
fathers said that?
that we are the we actually are
Yeah,
the
yeah.
the
Where's the
makers
law?
the
Where's the
makers
law?
the
Where
makers of
is the
that.
law? Don't be telling me. Stop it. Stop
Okay,
talking. Tell me where to find it. I don't want
that's
to hear your words. Anybody can put together some words. A
that's
5-year-old kid can put together words.
a
A
theory, right?
newborn baby can put together words. I don't want to hear that. Pay attention to my words. That junk
Okay,
that people be spewing on the internet because that's what makes people sound crazy.
that's correct.
That's how they're making people look stupid, is when they repeat stuff like that.
But
I heard
listen,
a guy that everybody's been
also,
talking about, and everybody's been going and listening to this guy. I heard him talking in court. And
but
I'm listening to this, and I'm sitting up there just laughing like, oh
oh,
God, no, he didn't just say
how
that stupid stuff.
about the banks cannot loan
It
credit?
doesn't matter. The banks can loan credit. The banks can lend credit all the time because credit is lawful money. They cannot lend their own credit. So again, pay attention to what I just said. Stop listening to those people.
Mhm.
Only bring up what you can prove. That's
Only
how they're going to kick your stuff out, is when you bring up stuff that they know you can't prove, that they know that you heard from the internet, because who do you think put that out on the internet in the first place?
they
It
did.
was those judges.
Mhm.
And do you know why they put that junk out there?
Okay, so you can go in there with it and they can dispute it, right? Refute
And be looking stupid. They
it.
can just sit up there and say, look at this mother gonna come up in here with this stuff. Look here, fool, I'm the one who wrote that. I'm the one who came up with the strategy to do this to y'all, and you gonna come in my court bringing my stuff to
Right.
me? And they kick you right on out. Okay, all of those so-called strategies you keep hearing about, these are not lawful strategies. That's why you don't hear me talking about them.
Right.
What I just told you, have you not seen that I've been showing you everything?
Right.
As I'm talking, I'm typing in and I'm hitting buttons and I'm showing, and I'm not taking you to no .com website. I'm taking you to the source,
The law. Yeah, the
because
law.
that's what Neil has to do. Neil
Right.
has to go to the source. I'm not taking you to no law. Please, this ain't the law. These are statutes.
Right. That
I'm
statute.
taking you to the statute. I'm not taking you to no law. If we were talking law, we'd be talking contract law. And
Mhm.
then they would say that the mortgage and the deed of trust is not a contract. It's not a trust agreement. Well, I got tons of law from case law or case text that says it is a trust agreement.
Mhm.
So again, we're gonna follow my lead. Keep all that other sideline stuff. That's not law. That's not how you win. Okay. I don't know who this is. Cole Waldner. This is an attorney website, if I'm not mistaken. Then the industry standard practice is to maintain promissory notes separately than the rest of the mortgage loan documents. When a mortgage, okay, I am going to suggest you go here and start looking at this. I put this in because I wanted to show something, and I'm going to prove that they cannot separate the note from the mortgage, the note from the deed of trust. I'm going to prove that. I'm not just going to say it. I'm not even going to bring up the fact that the Ninth Circuit Court has just referenced such information. Do that right there.
Because the only thing is on record is the
Wait, I need you to hold on a second. Hold on a second. Give me
uh,
1 second before we go on any further. I need to check to see who's all in our call, because I see 3 or 4. Okay, it's that other Cody that's still there. Okay, I just had to check to see because we had this is the consultation line, so other people do have the link. So I just need to make sure. Okay, what were you gonna say?
no, I was saying that the only thing is registered on in the county county clerk's office is the mortgage. The note is not there. They will say, oh, well, the note is not supposed to be there.
Of course, but they've already said that though. That's exactly what I'm telling you. But that's not proof that they can't do it. That's just proof of what they do. The courts are saying that they can do it. I'm about to prove they can't do it. Now, pay attention. Setting the UCC record straight on mortgage notes. This is AmericanBar.org. Article 9 applies both to a security interest in a mortgage note and a security obligation and the rights, blah, 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 to a mortgage note. So that's Article 9. That's what it was created for. Okay, can a lender still enforce a debt without a promissory note? Yeah, they simply just put in blah, 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 but that's not the question. It is separating the note from the mortgage. And I guess that is the question, because it says, can a lender, give me 1 second.
How about paying the debt? How can you have a debt?
Well, no. Look at what you're doing.
There.
Look at what you're doing. That's not even our conversation.
All right, stay on the convo.
You're just trying to share me your knowledge. This is not that conversation. This is me giving you options, and I want to give you the line of thought with the option. By bringing up that conversation, that has nothing to do with can the mortgage and the note be separated. Just go back and think about what you were about to say, and I know exactly what you were about to say. How does that deal with separating the note and the mortgage?
All right.
So then you lead me to off track and we'll be on a different conversation. Then I will forget where I was going. And then we'll have to go to something else, and then you will lose that information.
All right.
You follow?
Gotcha.
Okay. Here is the reason why they cannot separate the note. Supreme Court has made a recent case. I don't have the case site, and I cannot give that to you, but I can give you the Supreme Court. Pay attention. I can give you the Supreme Court's own understanding because it's in law. If you look at your deed of trust, your deed of trust evidences a debt. It references the note. The note references the deed of trust. Because the deed of trust references the note, it automatically associates it by reference. And because it associates it by reference, it means that the deed of trust and the note are linked to each other. You cannot separate it. There is no agreement to separate the two. When you separate the deed of trust, let's say you turn the note into a security. Okay, where's the note? Where did the note go?
Right. If you tell us that note into a security, yeah, where did it go?
Where does the note go? It disappears. It's destroyed.
Yeah, where did
when
it
you
go?
convert a note to a security, it's no longer a mortgage note. When you take a mortgage note and you make it a security, it's no longer a mortgage note. There is no statute that can change that because remember, it's a mortgage note. It evidences a debt. When you take that debt that is evidenced by that and you now convert it to a different instrument, that instrument has a different name under the law. Hold on. Watch this. What is a mortgage note? We're going to go to rocketmortgage.com. Now, this one we can go to. Well, yeah, as long as you understand that. That's the point. A mortgage is a type of contract. What makes it special is that it's a loan secured by real estate. Actually, not true. Your mortgage is not secured by real estate, and you have not brought that argument. When you got your loan, you could not have gotten it secured by real estate because when they gave you your loan, what did they say? They said, here, sir, you've been approved. Really? Without collateral? Oh, what the? Okay. So how is it that you were approved without collateral and then all of a sudden they're saying that your house is collateral for the loan? Your house, it's called after, dang it. Hold on.
I didn't have the house yet.
After something. Hold on. After, dang it. It's after acquired collateral. That's what it's called. To prove to you that it's called after acquired Yeah, and that's what I mean by doing what you just did. It'll take me off my train of thought, and I would have lost this. RACQULL. After acquired property collateral. Let's do the after acquired property collateral. After acquired property, personal or real property that a borrower acquires after having taken on a debt secured by all of their property becomes an additional collateral. It's called under 9 UCC, after acquired property, future advances. It's not a secured loan. It's after acquired property, which makes it not a secured loan. Well, they cannot use the non-judicial foreclosure on your property to acquire your property. They have to file a lawsuit. Why must they file a lawsuit? Because it's after acquired property. There's a reason why it's called after acquired, which means it's not secured. Are you understanding?
Oh, I'm in judicial. I'm in a judicial. I'm in not non-judicial state, but I'm in a judicial nonetheless. Right. The
No, no,
essence.
you are in a non-judicial process. Why? Because you didn't have a right to a jury trial, did you?
No.
Okay, you didn't
Mm.
have a right to a trial. Yes, you have a right to a judicial determination, but that ain't how it goes. Because anybody trying to sue me, we don't go through no process like this, especially when they don't produce evidence. This is after acquired collateral. The only thing they can do is sue you. They can't take the property because the
Mm.
property did not secure the loan. Go ahead and take a look at what after acquired means. I'm showing you the code.
Oh, I first got
Again,
the
as I
loan.
said,
I first got the loan. Didn't have the property.
that's correct. It's after acquired. After you acquired the loan, then you got the property, then you use the property to support the loan. Well,
If
it's not secured. A secured loan is a loan which the property was used to secure the loan. So when you were getting the loan, you needed collateral. That's why it's after acquired collateral. See, after acquired collateral refers to property pledged as security for a loan. Okay, there's no such thing. It's not a secured loan. The non-judicial foreclosure act, let's get it right. Non-judicial foreclosure act is also judicial foreclosure. Both of them are included in the non-judicial foreclosure act. So don't get it wrong. Non-judicial foreclosure act does not ever qualify an after acquired collateral as a secured loan. There is nothing in law that qualifies an after acquired collateral as a secured loan within the definition of 9 UCC and the Non-Judicial Foreclosure Act. After acquired property is a personal loan. This was a personal loan. This was not a home loan. You did not own the property, nor were you required to put up the property to be approved for the loan. You were approved for the loan way before you got the home. Go back and think about the process. Sir, we need to run your credit. Hey, you've been approved for a loan. Now you can go look for a home. Oh, you're going to have an inspection done. Oh, yeah, they need to do this repair and that repair. Okay, oh, we need your taxes. Okay, here are your loan docs. Here are the keys. Yes, we've already paid the homeowner. Oh, before you even sign this mother, we already paid them. Okay, thank you. Oh, wait. You said it's not a secured loan. What do you mean? We didn't sell it to you. Yeah, we didn't sell it. You bought it from a private owner. Well, if I oh, you're trying to tell us that it can only be a secured loan if you bought it directly from us and not from a private owner? That we didn't own the home, so it wasn't a home loan, it was a personal loan that you used to buy a home? Lord have mercy. I think you might be right. Are you understanding?
Oh man.
This
Yeah.
is what you're going to have to explain to the court, that this was a personal loan, that
Understand.
this was not a secured loan, and that there is no evidence on the record that it's a secured loan. This is a personal loan. The only thing they can do is bring a claim against my person for the loan. They cannot attack the home because the home under the Non-Judicial Foreclosure Act can only be attacked if it was used as security for the loan. Well, I got the loan before I owned the home, so it's after acquired collateral, and thus it cannot qualify as security for the loan.
Cause that's on. That's right. Cause that's what that's it. That's right there in the non-judicial and the judicial act.
Okay, do me a favor.
I'm gonna read it.
I want you to take what I just said, go back over this. I want you to go back over this conversation. I want you to go to an attorney and see if one of them can jump on the bandwagon, if you can convince them. If you
Right.
can, you will save your property and you will save so many other people's properties. You understand what I'm saying? Nobody has brought this up before. Now, we're not finished. Like I said, my job is to give you several different options. I've only given you two so far. So hold on because there's more. I've already told you to go to the SEC and file your complaints, correct?
Right.
Well, what you're going to do is you're going to contact the securitization trustee. Now, here, you're going to find out who the securitization trustee is. You're going to contact that securitization trustee. You're going to write them a letter. You're going to ask the court for a hearing. You're going to say, you just found out the securitization trustee has been trading your property on the market and hasn't been paying you. You're going to say it appears that these individuals are making an outlandish attempt to defraud you. All of the payments they owe me, I demand an offset of the amount of monies that I have not been paid. Are you following me?
Mm-hmm.
Okay. Now, what I want to do, I need your permission. I want to take this conversation right here and I want to play this for everybody to hear. Is that okay?
Okay. The whole thing. You're not gonna. Okay. Go ahead. I guess. Okay. I guess you
No,
can.
no, I need your permission. I can't just do it because we're not talking about anything specific. We're not,
Oh,
you don't have your address. They do have your name though, because I kept showing that thing about Skype. So they do have your name. But because of what we're talking about and the way the information is being delivered to you, I would rather give it to them this way where it's all natural than if that's why I tell people I don't prepare this stuff. Okay? So that they can see how the consults actually go.
all right. And you
I
edit
just
with
need your permission. You don't have to do it.
no. If it's gonna be some benefit for others, you think it's a real
I
good.
that's what I that's what I'm suggesting, that it will be a benefit to others. Now, do me a favor. Did we have you grab your mortgage to find that barcode at the bottom? I've had people tell me they can't find the barcode, and I've seen the barcode myself. I didn't know what it was for before, but I know what it's for.
Hold up.
So what I want you to do is I
Mm,
want you to contact the SEC, and I want you to ask the SEC, CHAT, does the BARCODEREPRESENT on a MORTGAGEDOC.
I
Question mark. What is the barcode on a
hold on.
mortgage star? I knew it was going to put barcode together. Go ahead.
Oh, go ahead. Go ahead. Finish while when I look for this. I can't put my
Okay. Now
hat on.
look, I want you to hear what they say. This is
Oh, that's
bank
interesting.
barcode scanning. Okay. Barcodes are used for credit, loan, deposit, and trust documents. While collecting documents and preparing can begin by placing the barcode cover sheet on the front of the documents rather than on the current tab being used for the within the paper files. That barcode, the way the barcode is put together, documents that the property's been paid for. You see, before they can take that property and start selling it and scanning it and transferring it, the bank gets paid. The bank gets paid usually within a week because usually a brokerage firm or someone pays the bank. So they are paid off. What most people don't understand, and that's not my fault, what most people don't understand is that there are several buyers for the loan. Now, this is an argument. I would not bring it up until somebody can perfect it, but this is an argument. The agreement was for you to pay off the loan, correct?
That's correct.
Okay, so when the bank received a payment for the loan, they call that person a buyer. But when that person paid the loan, didn't you satisfy your obligation?
Yep.
Because if you look at the UCC under presentment and payments, a third party can make a payment on your loan and they have to accept it. However, what you're going to say is the deed of trust says that you agree to this, you agree to that. Sorry, the deed of trust is not the payment agreement.
Mm-hmm.
The deed of trust is the security agreement. The
Right.
payment agreement is the note, and the note does not prohibit you from using a third party to pay off your loan,
Mm-hmm.
such as the United States Treasury.
Oh.
So do me a
So say,
favor.
where did you get
I
that
need
money
you
from?
to ask them. No, hold on, hold on. I need you to ask them in discovery or on a subpoena. I need you to ask them, and I'm going to show you how to postpone whatever process they're doing right now in court. That thing about asking for a sale, I'll show you how to postpone that. And you're going to even tell that to the court in open court, or you're going to tell that to the court in writing. Okay? You're going to let the court know that you want to modify. You want a loan modification. Because all this junk y'all been going through for the last 2 years, there was a moratorium. And they knew it was a moratorium. How many hearings have you had since 2020?
I didn't. There wasn't
So
no
there were
hearing.
no hearings from all the way from 2020 until now? No
That's right.
paperwork being served on you or nothing?
No.
Dag nabbit, I can't use that one.
Yeah, only. They wasn't trying to move forward because they put a stay on it during the moratorium.
Well, see, well, actually, they did
The
try to
only
move
thing.
forward because they've been charging you interest.
That's correct. They've been charging me. I'm a
Okay,
little.
they've been charging you interest. So because they're still charging you interest, there was no moratorium. The moratorium should have been on the interest. And it was a violation of your due process right for there to be a moratorium on the payments. And because interests are payments, they're called interest payments. For
Mm.
there to be a what you call it on the payments, a moratorium on the payments, which were supposed to be applied on the tail end, because I have somebody who they were
Last
delaying their
when they
payments. But
get these statements, I'm
go
looking
ahead.
at statements. That's what I should do.
Okay, what they did with this one guy is they were charging him interest all of this time, and for the interest that took place over the last 2 years, they now increased his payments by $200 a month.
Mm.
Uh-uh, can't do that. That's illegal because there was supposed to be a moratorium, and that moratorium was to push all of those payments until the end of the note, not the beginning. And so now they're violating rights. Now they had him sign a modification, and the person did sign the modification, but he didn't understand because you want to keep your home, you don't want to lose your home, so you're going to ask for a loan modification. That's going to prolong this even longer. Okay, and you're going to do the best you can to cooperate. Now, here's the other thing you're going to do
Cause they ask
immediately.
for a sheet. They ask for a
Doesn't
income sheet and this that. No, you know what the process is, right?
doesn't matter. Doesn't matter. Doesn't They can ask for whatever they want because
Mm.
over the next week you're going to take your property, which you are documenting, and you're going to document on record that your property was not security for the loan. And you go back over the information
And it
about
wasn't.
after acquired property. I'm going to put that in our link so that you can go over this information on after acquired property so that you can have it. See, this way, the people who are having mortgage problems, they don't continue to call me because we got so much to go over. I have some more information that I'm going to go over with you that is besides this. But
Mm-hmm.
that's the link for after acquired property.
Mm-hmm.
Okay. Then we have the link for after acquired property. Let me see. I'm gonna put another link.
And we talked
Give me
about the
give me
barcode
this.
too.
Yeah, that's I don't have everything about the barcodes, but I'm gonna put that in there. Now remember, you're getting a copy of this video. So you're gonna have this, but I'm putting it in a link so that you will also have these links and you can just copy all the links at the same time.
Okay.
Okay, and then load that on up. Okay, and then you can just load that on up and look at it and do your research from there. But what I'm going to need you to do is to understand that, I put the S, the does, and the together. Okay, what you're going to need to understand your position with these morons, with these idiots, is that they are about railroading. This is their process. They created it. All of the cards are stacked against you. So,
Mm-hmm.
how do you take those cards and turn them in your favor? Mr. I'm going to predict the future of what the judge is going to say?
Mhm.
Well, you have to document the record. You have to document the record because now you're going to take your property and you're going to put it in a trust. You are a sap packer, right?
That's right. Yes, I am.
Okay, do yourself a favor. I know, and I want you to pay attention to what I am saying because I can't say it any better than this. I know that you took and you created an appendix to your SATPAC trust because that's a trust. That's why there's a declaration of trust in it. And I know you put your property into the trust. The only thing you didn't do was a quick claim deed showing that the property was sold or put into the trust. The same as securitization process is. Securitization process is right here where they take the property and they put it into a trust. You took your property and you secured it with a trust. The only thing you did not do is go to the county recorder and file your quick claim. I mean, not quite title. Come on now, quick claim. The only
Quick
thing you
claim,
didn't do was
quick
file the
claim
quick claim
deed. A quick claim
deed.
deed.
That's the only thing you hadn't done because you've already created the appendix. You already took the property and put it in the appendix of the trust. The trust has been established for how many years?
For some time. That's
When did you
before the
become a sap
homeowner.
packer?
Are they during the time when you did
When
the
did you be?
also doing
The 2012? No, no, that was you're talking about when I announced it on video. That was 2017, 2018.
how about
So,
defrauding
but the
homeowners?
but the defrauded
Defrauding homeowners during that
the
time.
defrauded homeowners. Oh, you've been around since 2012.
Defrauding homeowners.
Defrauded homeowners of America. So you were around with redress UCC,
No,
redressright.org, and all that stuff, right?
after that. Defrauding
Okay,
homeowners
so
has been another.
2017, 2018.
That's
The
yeah,
defrauded
right
homeowners
there.
of America started in 2012, but the defrauded homeowners of America making you guys part of the agreement and giving you a percentage, that was 2017, 2018.
That's correct. That one.
Okay. All right. So now that you know that, and now that you know what you already did and what you need to do to complete the process and file on the county record, then you're going to do a loan modification only after it's filed on the county record.
Mm.
But you got to make the beneficiaries have to be the beneficiaries. So whoever the beneficiaries of your trust agreement is, okay, beneficiaries. So you got to go back over your SAT pack and see who the beneficiaries are.
Yeah, I gotta
It
pull
cannot
all
be
the
you.
stuff up set by yeah.
You got
Pull,
to do it, but I'm
yeah.
trying to give you a way out, or you can create another trust agreement. But we don't want the court to say that you did this to do this
After the
and do that and do
after the
this.
fact. After the fact, yeah.
Exactly. That's why we know that because you're a stat packer and because you have a stat pack and because you already have the trust established. And when you do your quick claim, you're going to do it notarized and put that on the county record. Okay.
Mm.
By the way, you're also going to go to the county recorder's office and you want to tell them you want all the reconveyances and the, um, what is that thing besides reconveyance where the satisfaction, satisfaction of mortgage, satisfaction of, satisfaction of mortgage. So you want the satisfaction of mortgages or all of the reconveyances on your property that is filed with the county. And then you want to ask them, are there any other records associated with reconveyances on my property? And bring your phone with you, turn on that private recorder, keep it in your pocket, don't show it to nobody, don't try to make it look like you're trying to get somebody to say something, but document the fact that you were there. Document what they're saying, because I promise you, the law is if they satisfy that mortgage, we're going to do satisfaction of mortgage act. Don't worry about it. I haven't even talked about this for a while.
This stuff is some even documented already in the on paper in the records when you pull it up from the city records.
I don't know
It's on
why
your.
I did satisfaction that way. I know it's an A. TISFACTIOE. Why I spell satisfaction that way, but that's because I got so much on my mind. I don't want satisfaction of mortgage act. Oh, this Pennsylvania. I don't care about Pennsylvania, but every state has a satisfaction act. Okay. What state are you in?
New York.
Oh, NYC. I was just listening to Kid from Kid and Play. Man,
Okay.
that fool's all right.
Yeah, Kid
You
and
know,
Play.
you just said New York, and he talks about being Jamaican. He's mixed with
Really?
Jamaican. His father was Jamaican. His mother was Caucasian, and so he
Re-
talks about that. And so yeah, when you look at him, you don't see
Yeah,
Jamaican,
you
but
can
when you
tell.
hear him
You
talk, and he
yeah,
does
you can
all the
definitely.
Jamaican talk, you
Yeah,
can man,
it kind of throws you.
you can tell that he grew up around that. So
Yeah,
yeah, but yeah, um, this is Satisfaction of Mortgage Act. Satisfaction of Mortgage Act. You need to
high
read.
top.
All of you need to read the Satisfaction of Mortgage Act. It's not long. It tells you how to get a mortgage satisfied. Now, this is the other thing. Now, I want you to pay attention because I haven't actually talked about this in depth, but I'm going to talk about it in depth to you since we're going to let everybody else hear this. What you're going to do, did you keep copies of your tender of payment to these individuals?
Yes, I did.
Okay, what you want to do is you want to send them a bill. You want to say, I paid you and I presented tender to you. You were supposed to fill out, and you're going to send them a 1099-A. You're going to put your information in the way it's supposed to be. That's your research, not mine. I cannot do that publicly right now because it's a part of one of the organizations we're working out. Okay. But you're going to send them the 1099-A. Say you were supposed to send this to the Treasury and they were supposed to reimburse you, but you failed to follow the rules, follow the law. So here is your 1099-A and here's your 1096. Take that with you. This will serve as payment. If you do not accept this, then you will owe me whatever the value of each of those two items are. You send them both of those items and you put I would do two separate 1099-As for both of those items if it was me.
Mm.
You send them a letter, you have 30 days. If you don't resolve this in 30 days, then you will, at the end of those 30 days, agree to pay me the amount received by you as a result of this transaction. You create and establish the debt between the two of you. Okay? I want you to follow me. Then at the end of those 30 days, you're going to say, hey, I know you ain't going to pay. I know you ain't going to pay me, but I refuse to let you go. And you're going to hold them accountable for the damages, but you're going to forgive the debt. By all means, you better forgive your neighbor their debt. So you're going to forgive the debt, but you're going to hold them accountable for the damages, but forgive the debt. Say, I will not even make an attempt to try to collect on this debt ever again, on the
So
monetary portion of this debt.
so what triple damages the debt?
No, I wouldn't
I
do
mean
triple
damages,
damages,
not
no,
the debt.
because you're just going to do it specifically for the amount of the instruments, no more than that. Now,
All right.
I tell people they could do assessments and fees, but why? You got two instruments. Why do it for more than that?
Mhm.
Why be, what's the word? Greedy.
The two
Why
instruments
be
is
greedy?
the mortgage and the note.
No, you're not paying attention. You sent them two different payments.
Oh, yeah, yeah,
Those
yeah,
are
yeah.
instruments.
Okay, right. This show.
Okay.
Yeah,
We're dealing with instrument law.
that's
All
correct.
right. Also, please note what an endorsement is. On your mortgage, there is an endorsement. Pay to the order of without recourse.
Mm.
That's an order for payment. Pay attention. Pay to the order of.
Mm-hmm.
So somebody received a payment.
You got that right.
That is an order. So somebody received a payment order. Okay, where is the claim that this mortgage has not been paid? Well, that just means they purchased it. Yes, if they did purchase it, then they need to demonstrate that they didn't pay it off. They may have purchased it, but they need to demonstrate they didn't pay it off. The reason why they purchased it is so they could trade it on the market. That's going to be your presumption. The reason why they purchased it so is that they can trade it on the market. Do you follow me? Are you
Mm.
understanding what I'm trying to say? The
Right.
reason why they purchased it, because they're going to say they purchased the mortgage. That's just proof that they purchased it. The reason why they purchased it, it is believed, is so that they could trade it on the market because they couldn't trade it on the market without my permission because it's still my property. I'm
Mm.
still a party to that mortgage. And how can they trade it on the market without my permission? So if they don't have my permission, that means they're committing fraud. But of course, they're not committing fraud because this is done every single day. So if it's being done every single day, the reason why they purchased it is so that they could trade it on the market.
Without your permission. That wasn't part of the
No, they
contract.
could trade it on the market because they purchased it. They purchased it to pay it off. It's been paid
Oh,
off. It's been paid in full. That's what the
okay.
endorsement is
They
for.
paid. Okay.
That's what
To
you're
the
gonna
order.
say. That's your presumption.
Oh,
See, they
okay.
want you to bring proof of this and proof of that. Well, you're gonna say right here, it says paid to the order
It's
of.
a
Well,
it's a stamp.
somebody received a payment because that's a payment order. It doesn't matter if it's a stamp, it's still an order.
Right. And whoever
Like a
paid.
court issues an order, somebody has to obey. A pay to
Mhm.
the order of is a demand. All right, God. Sorry, I don't want to tell y'all this because y'all don't deserve this information. Uh, hold on. And you don't. Some people keep telling me, you don't be giving us everything.
Paid to the order.
I want you to pay attention. Demand order. A demand order means an order placed by an authorized demander for any product listed in annex. Demand orders are done all the time. Demand order. Order versus demand. Okay, what's the difference? Is that order is uncountable arrangement. We don't want that type of order. That ain't type of what we're talking about. We're talking about a demand order. So let's do the quotation so that you can see. That even gives us the meaning. Okay, it even says demand order meaning. What color code is an on-demand order? Nobody said on demand. We said specifically demand order. GST appeal against demand order. Okay, demand order meaning. Let's do demand order meaning, and then I'm going to do the GST appeal. I mean, the order that they're trying to get it done. A demand order means an order placed by an authorized. No, that's not the one I want. I want the real one. I don't want an on demand. I want a demand order, and it's giving me the same junk. So definition of demand. No, we don't want the definition of demand. Hold on. That's why I did it. Do it again.
There is a distinction,
Right.
huh?
Oh, demand order? There is a reason why it's called a demand order. That's why I can pull it up and type it in here because the meaning of demand order is not on demand. It's a demand order. Really, demand order format. Look at that. That's interesting. Demand letter template. Okay. But when you understand what a demand order is and what a demand order amounts to be, ladies and gentlemen, demand order is a check in most instances. Watch this. This thing has format. Let's put this.
One word or phrase can just change
You
the
see,
whole.
pay
Uh,
attention. Demand draft money order. A demand draft money order? Lord have mercy. I ain't never seen that before. Is pay order and demand draft the same? Let's do a pay order because isn't that what it says? Pay to the order of? Pay order can be cleared in any branch of the bank for the same city, whereas a demand draft is cleared at any branch in the same bank. Interesting, huh? Ladies and gentlemen, you have to do your research before you do any demand drafts or demand orders, but a demand order or a pay order is what you want to focus on. Feature, pay orders are pre-printed with not negotiable. Demand draft is a negotiable instrument. Ladies and gentlemen, I know better than this. But they say a pay order. Pay to the order of is not negotiable. You cannot change the parties, but if it's a blank endorsement, meaning no name on it, it acts like a bearer bond. Whoever is the holder of that gets to control it. So, a demand order, that's your research for the future. But because you are saying that you paid them, because you sent them a payment twice and they failed to dishonor it, properly as required by law, then by the
On it.
law that they're required to operate under is the UCC. They're required to operate under the UCC. That's not your requirement. That's their requirement. Now I'm going to do the GST. GST. I think GST is what I think it is, but hold on. Demand notice can be issued by GST officials for short payment or non-payment of GST in the following two different situations. Okay, so a demand notice can be issued for payment. Follow what they do. Do what they do, ladies and gentlemen. This is India. Pay attention. That's because I'm on Opera. Opera puts us outside the US. Uh-oh. Look at that. Section 73 and 74. Interesting, because GST just ain't for India. So let's do USA. Let's do that right there. Executive order on American supply chain. The White House. February 24th, 2021. Anybody know about this executive order? Huh? Interesting. Demand letter is a document sent by one party to another in order to resolve a dispute. So what about a demand order? That's what you're doing when you're sending to them those two and you're letting them know they have until. And like I said, I can't say too much more because this is what our company will be doing. But they have until a certain time to pay. Okay? That's what you're doing. All right. Now, let's I'm gonna do us a favor, you and I. Go back to Skippity-ite, and I'm gonna